Before we dive into today's episode, a special shout out to our sponsor, Quid Pro Quo. Are you a law firm looking to scale or sell your practice? QPQ's expert team can help you unlock your firm's full potential. Stay tuned for valuable insights brought to you by QPQ.
Hello, and welcome back to the Marketing Lawcast. I'm your host, Jennifer Goddard, and I'm here today with my guest, John B. Henry III. He is an estate and elder law attorney in the state of Texas. And just give us a little bit about your background, John.
Absolutely. So, as Jennifer shared, I'm an attorney in Texas. My practice focuses on helping all parts of the family tree through trusts and estates and disability planning. And so we have an office in Houston, specifically in Bel Air. It's a sub-city of Houston. And we also have another office in Rockwall, which is east of Dallas. I'm a double board certified attorney. So I'm a certified elder law attorney by the National Elder Law Foundation. And I'm also board certified by the Texas Board of Legal Specialization in estate planning and probate law. So what that means to most people, what does that mean? So it means that I'm one of 20 attorneys in the state of Texas that hold both of those certifications. And so for me, it's a years-long journey and a blessing to say that I think about planning comprehensively for all those parts of your family that could affect the will or the trust or the guardianship or the probate that may be necessary along your life journey.
And so you have two offices.
That's right.
There is you and someone else, another attorney in your office?
Yes, so I have an of counsel that has a tax auditing, trust administration background that just helps us on our more complex planning. In a few other areas of practice. And then we have our firm administrator, who's my sister, who I attribute through God's grace. The development of my firm and her perspective in different industries has been vital. And then we have our senior managing paralegal, several other paralegals, file clerks, a receptionist, who I like to also call Mom, who is our pinch hitter. She's so overqualified, but helped us during the pandemic when we realized that our a lot of people were going virtual, right? And the phone or virtual receptionists were overloaded. They were understaffed, but a higher volume. And she stepped in during the pandemic and has been phenomenal ever since. So I get to say hello to my mom every day, and it's a privilege.
Awesome. Having a team like that, I was going to ask you, how do you keep up with two offices? And I think you kind of just told me you have a great team.
That's absolutely right. Along with the business processes, we continue to look at to make sure that they are centered around our values and the fact that we remember that we're human. I think that's the other part in developing a law practice, maintaining it, is remembering that you and everyone around you is human. And that has to be part of your calculus. Otherwise, the math is wrong.
John, I met you just about a month ago at the Texas chapter of NALA there in Galveston, and you were speaking on the topic of how to deal with difficult clients. And that will be kind of what we're going to delve into in this interview today. But one thing I always like to ask everyone that I interview who is an estate planning or elder law attorney, because it's such a niche, how did you come to choose to go into this field?
Sure. Well, in short, it's a blessing to say it's the place where I found myself aligned with my values, with communities that I wanted to serve. Just about me personally, I have a very, very large family. When I say large, I mean immensely large. On my dad's side alone, I've had two cousins a couple generations back that had 22 children each. I've had relative that was recognized as the oldest living person by the president in the United States in 2000. She lived to be approximately 109 years old. And I've had multiple members of my family live over 100. And so it is something that it shapes my vision of the world, that people are both young and old, disabled and not disabled, and all those are labels. And we have to move beyond those to see people as people. And I think that's why I chose this practice area, because it is certainly of service to a community of people.
One of the reasons I love to ask that question is it seems like in estate planning and elder law, I find that every attorney has a personal story. And what I've kind of learned through the years is that this isn't just a practice area. It's not just a career path. It really is a calling.
I think that's absolutely right. And it's one that when you answer it, it is self-fulfilling. It's so fulfilling. And I think that's why we can turn back to it over and over again when you see the results. I helped a client recently with a trust matter who has been disabled since she was a young adult. And the trust, even though it's well funded, their annuities coming in a few years, they were just cutting her at the knees in her budget. And she's like, I'm just physically disabled. I understand, the issue of federal law, but I need more to live my life the way I want to. So we went through her trust agreement. We went through her financial statements, and I gave her different points to address with her trustee on her own. And she came back and said, you know what, I feel empowered now. And so that, having days like that make it amazing to be a trust and estates lawyer.
Absolutely. And when you're in these fields where you're very personal, your relationships with your clients are very personal. People talk about this being a transactional practice, but it is, but it's also very personal. And that kind of leads me into our topic for today, which is, how do you deal with difficult clients? Can you tell me a little bit about how you came about, that people asked you to speak on this topic, and how you kind of came about to having kind of a plan? Here's how you do it.
So frequently I'm asked to speak on topics of practice development and technology by Texas NALA, which is the National Academy of Elder Law Attorneys. And so they said, John, we want you to talk about how do you deal with difficult clients. And I'm very fortunate to have my firm administrator, who's also my sister, who gives me a different perspective and really helps us to develop processes and procedures to deal with things that are really misalignments. And so that's how I chose this topic, which was to dissect the idea of difficulty. And what does that mean? Is it because the client is difficult? Is what they're dealing with difficult or complex? And is the way that are the ways that we are handling it assisting with kind of segmenting out the difficulty and giving a pathway, not that will be less difficult, but maybe at least manageable as we navigate through those worlds of disability and death and administration of estates.
When we talked about this, you have basically 5 pressure points that you've identified in client relationships, where sometimes things can go awry, and that can result in this concept that someone is difficult. So you kind of want to walk us through that?
Sure. So my 5 pressure points are, the first being client status. Should someone be a client? I think that's an ongoing question from beginning to end of a relationship. Now, sometimes we can't because of ethical rules decline further representation, and there are absolutely valid reasons why you shouldn't, and the rules are the way they are. But it is an ongoing question for us to assess, to determine that alignment with our core values and these other areas that I'll talk about, which is the scope of the representation. Sometimes people come to us and things can morph over time. And are we then agreeing to assist someone with a trust related matter when they came to us for a guardianship? And have we documented that scope of representation change? And did we give them an accurate expectation like we did with the guardianship in the beginning? Because sometimes that is kind of when we have that change in the scope of representation, sometimes we don't go back to reiterate what we might otherwise do in the beginning, which is that expectation setting, that documentation. And so we want to make sure that we do that. And then communication, the rules require that we do, and it's reasonable that we do. But do we tell people what's in our sauce? How do we communicate? And how do we expect our clients to communicate is another part. Definitely another pressure point is payment. Payment is different from the fee we set. Payment is what we are intending to collect. And then the last one is participation. I think in developing my paper and presentation for Texas NALA, there were a lot of revelations for me personally or ongoing revelation. Our rules are meant to regulate, in terms of the rules of disciplinary or professional conduct, to regulate us as lawyers. But we don't also have then a set of rules or expectations or environment settings for the client. And so as we are navigating these client relationships, it's, I think, required of us to then define, what does client participation look like? Should a client review their email every 3 to 5 days because you probably might send them something, or their client portal? So those are the pressure points that I talked about, and I think are critical in any client-attorney relationship.
So when we run into one of these pressure points where things feel like they're starting to go awry, what are some of the steps that we can take to kind of either get things back on track, or if we have to, move the client along to someone else?
Well, I think the first is to determine our mindset. I talked about this, and I talk about this quite frequently, is sometimes the difficulties we're led to is because of a mindset issue. Sometimes are we acting as the tour guide on a hop on, hop off bus, and clients can go here and there and experience it. And then when they don't end up on the end of the tour you're on, then is that because of our mindset, right? Because we do want to create these client experiences that give clients that room to be people. And I'm very big about that, remembering that people are people, even in the midst of the formality and the regulations and the rules and the law. People are people. However, sometimes we have to sit back and say, is it a mindset issue with this particular client? And have I approached the director of my ship the right way? That's the thing. So I think we begin with our mindset, and then, call your hand on it. The second is, then you look at your policies and procedures and determine, well, has a client been checking their portal and been checking their email? Have I been getting the documents back, the responses that I need? And so as you go through these pressure points, you're saying, okay, is this aligning with my policy, my procedure? And if it's not, I think then that gives us something discrete to touch and feel, because that's often in difficult client relationships. We can, not unlike a client, we can attorney and go inside of ourselves and go here, there, and everywhere. Because I love to say clients will client anytime they can client when a client wants to client. But as attorneys, we can do that too. And so we do need some touchstone of how to determine difficulty. And so looking at your policies and procedures on payment, on communication, on participation makes it specific, right? And it takes us out of that more emotional world of, they just did this or didn't do it, and I am just utterly frustrated. And then you have tools then to communicate with your client on either modifying the relationship or terminating it.
When we talked about this earlier, you mentioned that sometimes when you find a misalignment, you have a team meeting about this. Can you kind of talk to me about that?
So we have a team meeting or committee meeting from beginning to end. We have them throughout the life cycle of a case. So that could be determining alignment in the beginning and the intake process. We looking at these sort of pressure points, and then determining, should we have this client retain us in the very beginning? But it could be in the middle when a client has fallen out of alignment with these sort of core principles or issues. Then we have a meeting, a status meeting about that client and how we want to approach it. And definitely we communicate that to clients from the beginning, potential clients stage, to the very end of the client relationship, so that the clients know that it is a formal approach that we take, and that it's also thoughtful. I think that's the other thing, that sometimes we are dealing with public's perception that the lawyer just is going to do something and just be a lawyer and just say he, she, or they don't want to deal with it. And in that way, in our firm, then it makes it something that they understand, oh, well, this is very thoughtful. There's a committee of people, and it's not just the attorney who says he's had his fill. And so that is our approach that we take.
So in your practice, where do you find that the biggest or the most likely pressure point where you're going to have a misalignment?
I think frequently it is on the issue of communication and participation. It's going to be those two. I won't say one or the other, but usually communication and participation are intertwined. And as a law student working at legal aid, one of the things that I came up with, and it's in our contracts, you must participate in your representation. A lot of times people will come to us in these very difficult situations or important situations, if it's planning for trusts or estates, and think that the lawyer will just do it all. And I think that is having that participation policy and communication policy helps to put those two things in alignment. And then it also helps you to see when clients kind of maybe aren't aligned with those two things. So I would say it's communication and participation.
So what do you do differently if you're kind of thinking about dealing with difficult clients? How can I avoid these things coming up and somebody, sort of becoming the relationship becoming difficult? What are the things you can do proactively to avoid that?
So one is to do your case audits. That's something that you should be doing. And some firms it's weekly, some bi-weekly, some monthly. I think that you begin with what is manageable to you in your practice. I think that's one of the biggest steps that you can take in firm development is beginning with what you can do. It's great that we hear about communications policies and participation and case auditing, and you're saying, I can't do it weekly. Maybe I'm not staffed to do that, but begin with something. So I think it's the case auditing, because then you'll see patterns. And then with that, you should have some concomitant or related process that says, well, they've fallen out of alignment. How do I address that? How long do we let it go on? What is our firm rule? So that's the next phase of that, is to say, what is my rule? So that people will know, and you can already have it pre-drafted. This is our policy and participation and communication. We're sensing and seeing something that falls outside of it. We encourage you to go along this way because you came to us to achieve this goal. And then the next step in it is, when do you actually suspend someone if they've fallen completely out of alignment, saying this is going to stop and we cannot move forward. And then you have to determine next, is that something you can move forward with? And if so, under what terms? And then how do you engage the client directly with that? And that's often a in-person client meeting. Those are powerful because people don't have to do as much in person as they've done before. Sometimes people just need to see you face to face. But if that's not possible, certainly a client phone call where you talk about it discreetly and directly, and note that in the client portal and file, we've gone over this. This is what we decided to do, and this is how we will move forward. Because remember, if it's out of sight, it's out of mind,
Right.
and that certainly applies in client relationships.
I think a lot of times I find that we're afraid to have that conversation. Maybe we don't admit it, but there's that gut feeling that I don't really want to confront that. How do you overcome that, and how do you kind of make that work?
So one, like I said earlier, I'm very blessed to have my sister who's a firm administrator, and to have her say, hey, we have a policy. So one is the policy, right? So with certain things, you have to have the standing rules. If it is payment, this will be addressed, let's say, in 5 days or 3 days or on the day of. On communication, within a week, someone will receive a discrete message of this kind. So then it takes out of that nature where I think some of it is a client perception that you're just coming up with things, right? And and then there's that flexibility, because then, well, it could be anything then. Well, no, we have a firm policy, right? So that is something as a touchstone in the client relationship, then someone understood you took the time to think about them, and that it isn't something that is just being manipulated as to how you see it, although you should if it needs to change. But you begin with this issue, it's the same day. Issue, maybe 5 days. And then you come up with, what does that look like? Is it a message in the portal? Is it a phone? Is it an email? Is it a client meeting? So that way you disarm this idea of, I'm afraid because I don't know what to do. No, I know exactly what I'm going to do. Here's the plan. This is what we decided to do when this happens. And then you have a playbook, right? And I think that's the other part that's fearful, is that you're then reaching into something you probably weren't prepared for. We don't leave law school, and sometimes working even at large firms, you're not prepared initially with those type of tools because it's viewed as someone else's role and someone else's job. But I think in this, I'm a proponent. I'm going to say violate your own firm rule. I'm not saying that, if a firm says it's for someone else in the firm to handle, but I think that you have to develop this framework of, if this happens with a difficult client or client relationship, here are the rules that I'll follow. And if it's not for you alone to say you should handle it that way, propose it to your managing attorney, your partner, the firm committee. Say, hey, I want to do these things internally. I want to be proactive so that I can maintain healthy client relationships. And sometimes maintaining that relationship is terminating that relationship. But I do want to have some framework that I see our policies don't necessarily address.
So if I'm an attorney that's maybe never had to, or I shouldn't say nobody, I shouldn't say that. Not that I've never had to deal with a difficult client, because I think everybody has to deal with a difficult client at some point, but I've never had a policy. I've never had a protocol. Where do I start?
You start with, well, I'm a little old school, so I say pen and paper, but you can start with your OneNote, your Evernote, whatever it is that you use, and say, start with payments, start with start from the very top. Say, if someone does, my policy is that I want clients to respond in less than 3 to 5 days, or maybe a week, depending on what you do. That's up to you. And then I will respond in this manner of time. I think that's the other thing about communication and participation. You need to let your clients know how you will participate and how you will communicate. Because often people have this idea, because of the advances in technology, dealing with people in the financial services industry that are backed with a different level of funding and staffing, that you can respond in the same day or 24 hours. And sometimes you just can't, right? You are human. You are likely going to have more than a handful of clients to adequately fund your practice. So then you have to think, well, then my participation, my communication will look like this. For me internally, it helped me to segment out my time, where I do, let's say, guardianship on Monday, elder law on Tuesday, and I let clients know that. That's what I say, letting people know, because I have family from Louisiana, what's in the gumbo, but what's in the sausage, what's in the spaghetti, how do I make it? How do I get there, right? And then you have to put that same sauce together for the client, right? So when I message you, it's not hot potato. I need something back from you with this within 3 to 5 days, right? And so that way your client knows how to participate, knows what is good communication. So you start from that top level. And maybe it's something just as simple as, my response time is this, your response time is that, right? And it's something then you develop over time. Response then maybe in advance. So what's the next step on something like this? If a client is a trustee or guardian or administrator, maybe they do accountings. So then I spent time going through the code and then developing, well, what does participation look like, right? Remember that methodology, pedagogy problem we have. Well, the code says an inventory is due in 90 days. Okay, do you want your client to give you the worksheet to draft this inventory on day 89? Right? So then you take those responsibilities and then you say, in this type of case, participation then looks like, I want worksheets for this and this and this within 30 days. You can supplement it. I understand you may not have everything, but logistically, I need to have these things internally by this deadline, because I'm kind of human. The court is staffed by humans. And so for this to be drafted, reviewed, and me to sit down with you, I then need this amount of time to do it, right? And so some of it, it's really going to help you in your own journey to develop. Maybe you've never thought, oh, shoot, the law is not a checklist. I shouldn't be saying 90 days, or discovery maybe have to respond to in 30 days. Well, when does the client have to get me their responses? when do I have to get it back to them? And so some of that is we have that backlogging when we look at the procedural codes and the estates and trust codes that will happen as a matter of just logic
Mhm.
because they start collapsing at certain times where things are then due together. So then we have to sit back and say, oh, well, now I can see my participation in development has to operate on a different timeline for me to comply with these deadlines, these expectations.
So you're suggesting that it should be written out,
Absolutely.
and is it something that you sit down and do at once, or is it something that evolves over time? You're constantly kind of working it and massaging it?
Yes, so it develops over time. And so don't be afraid if it's just a one sheeter, it's a one email, it's a one message, and you say, here's when you respond, here's how I respond, here's when I develop the case and this and so on. And maybe it's 2 or 3 lines, but those 2 or 3 lines can be the difference between hundreds of phone calls and maybe 100 phone calls, right? People asking for an update. Well, when do you update clients? Maybe and again, in the beginning, you have to remember and always remember you're human, but maybe incorporating a client update. And maybe in the beginning, maybe you can only do it in a month, right? But then your clients will know and expect this is when I will get a formal update outside of the other communication you do. I'm going to do a top-down review and give you this is where you are. Those 2 tools right there took our firm from, we had, and admittedly we do have a number of clients, but I think it was 1,500 to 2,000 no, it was over 2,000 phone calls in 1 month to about 200.
Wow.
And so those basics of here's when you're going to hear from me, here's when I'm going to generally do this, can just decrease the amount of those, not unnecessary, because it's necessary that people understand where they are, but it becomes unnecessary when you give them an expectation of when they're going to receive it, right? Them meaning clients. And so, and clients will honestly will vibe with that. They'll say, okay, well, my attorney will update me every 2 weeks or every week or and I know that's when I'm going to get this. I know I will still get, and I would put in there in that message, you will still get other communication, probably from other people. But I think the other thing, and I know it's a lot, and the third thing I would do is address, does that apply to every member of your firm? Right, because sometimes people may be able to reach your assistant more frequently than you, right? That's another development in the communication policy for an attorney is to say, am I at the point in my practice where I can't take unscheduled phone calls, or I have to put unscheduled phone calls at the end of the day every 3 days, right? And knowing that you can do that and that's still healthy and good communication.
And how do you communicate that to the client? I mean, is this on the intake? How do you get everybody on the same page?
So it begins by, we have an addendum. So it isn't an intake process. Our firm talks a little bit about that. The intake specialists, they will just give a little bit about our process. And that's a very big selling point to a lot of people. Like, oh, they're thoughtful about how I'm going to hear from them, when I'm going to hear from them. And then they have a whole page in their contract about how that works. So it's an addendum to our client agreement that says communication policy, and that's all it's about. Participation policy, and that's all it's about. Now, some people, it's doing a welcome letter or something on Canva, and so it's a welcome kit, right? And so they distill that into something visual because not everybody likes to read a lot of words. So maybe you begin with like a Canva presentation that's a welcome kit that's maybe 3 slides, maybe 5, and send it to new and existing clients. Here's our new policy. It is effective as of this date. And so a welcome kit can help do that. And remember, you want to send that. If you have the ability to use MailChimp or other mail or marketing tools, send that to your existing clients, maybe once or twice a year. Remember, this is our policy. It's great to hear from you. Love you. Want to know about the kids. But remember these things about our process. And so that nurtures that healthy idea.
That's great advice. That's really a great idea. Well, we're kind of starting to wrap up here,
Yes.
John. My biggest takeaway is the idea that dealing with difficult clients begins with the mindset.
Mhm.
Am I on point there?
You are on the point. You're on the head of the point and all around the point. That is it. It's the mindset. You have to determine, how will I operate and speak about my process, my procedure, my firm, and know that sometimes that mindset may have to shift with certain clients. Some clients do need the firm director of, I'm the pilot, A to B. This is where we're going. Y'all enjoy the ride. Here's the liberties you have to move about the cabin, and that's it. Other clients don't need necessarily that type of specific and very forceful hand holding. Your process should be that clear and specific, but others you may be able to use a more gentler approach. But I think always reviewing your mindset and having some general way that you approach the client relationship is absolutely right from the beginning.
Awesome. So, John, if you would share your website in case people want to find out more about you or maybe reach out to you through your website.
Absolutely. So it's www.johnhenrylaw.com, and you can find my firm there. And we are working on, we haven't released it yet, but we are going to be starting a CLE series beginning here in Texas that talks about and addresses this issue of how do we translate and educate our staff and our clients on the idea of client education and firm education, right? So that we can kind of add on the practical element of implementing the law into our legal education process. So you will find a link to that next year on our website when it is released.
Terrific. So if you guys want to follow John, you can find his website at johnhenrylaw.com. And then I'm sure from there you can find all of your social media.
Yes, you can.
Connections, and we will have that in the description for the interview as well. What an absolute pleasure it has been to visit with you today, John. And I look forward to having you back on the podcast to talk about some of these other practice management issues.
Absolutely.
That's a wrap for today's episode. And a big thank you to our sponsor, Quid Pro Quo. QPQ is your partner in law firm success, offering expert guidance on scaling, selling, and optimizing your practice. With a team of experienced professionals, they bring real-world insights to the table. Are you ready to take your law practice to new heights? Visit their website at www.quidproquolaw.com to learn more and start your journey toward a thriving, invaluable law firm.